Welcome to the Animal Law Podcast. This is Marianne Sullivan. Today I'll be speaking with Sarah Hanneken. She'll be talking about Brown versus Kemp, which is a case that was very recently brought in federal district court in Wisconsin, and it's seeking to invalidate some of the newly enacted amendments to Wisconsin's so-called hunter harassment statute on the grounds that they violate the First Amendment and due process rights of activists. And, these hunter harassment statutes have been around for a long time. I don't know whether you're familiar with them, but in these current days when we're seeing the free speech rights of animal activists compromised on so many different fronts, it's interesting to see one of the first types of activist harassment, which is what they really are, being revisited and made even more egregious. And I think you'll be really interested to hear from Sarah about what this case is about, and we'll be keeping an eye on this case to see how it turns out. Before we get to the interview, I'd just like to quickly remind you that, running our hen house, which produces the Animal Law Podcast, along with the Our Hen House podcast, is something we really love doing, but it means that we have to ask for your support. So if you can support us, please go to ourhenhouse.org/donate, and you can join our special band of supporters, whom we call our flock, or you can make whatever donation you can afford and are comfortable with, but please do something. The only way to keep animal-friendly indie media going is through supporting its efforts, in this case, Our Hen House and the Animal Law Podcast. But now to Sarah Hanneken, who is one of the attorneys working on this case, and she's a litigation fellow for the Animal Legal Defense Fund, where she's been working since 2014. Welcome to the Animal Law Podcast, Sarah.
Thanks, Marianne. I am pleased to be here.
I am pleased to have you because I'm excited to be talking about this case, which is in early stages, but still really an interesting case. And I don't think we've ever talked about a hunter harassment case on the Animal Law Podcast, so I really value this opportunity. Let's get a little bit, I always like to start with the facts before we get to the law. And so let's get a little bit of background here to kind of set the scene for people. Maybe start off with who Wolf Patrol is and what they do.
Sure. So Wolf Patrol is a unofficial organized movement. They actually describe themselves as a movement that operates mostly in the Midwest, and they essentially are composed of wildlife activists, environmentalists, various people with those types of interests who go around public areas, public forests, and monitor hunters. What they're looking for essentially is any illegal activity and even just morally detestable activity that is of public interest. And so Wolf Patrol is actually not a plaintiff in this case, but they are very relevant because the statute that we are challenging, that we can talk about in more detail, all signs indicate that it was enacted in response to Wolf Patrol's activities in the state.
And the state is the state of Wisconsin, right?
Yes, the state of Wisconsin, my home state. So it's fun to be able to sue my home state.
Always an enjoyable project for us all. So Wolf Patrol isn't really focused on wolves. They're just focused on monitoring hunting in general.
They are primarily focused on wolves. They started around the time that wolves were delisted in Wisconsin. They were, now I think they're listed again, actually, and it keeps going back and forth. Yeah, they're currently listed as a protected species. They were, up until a couple years ago, delisted, and so people were allowed to hunt them. Now they're no longer allowed to hunt them, but there are a lot of anecdotes of that law being disregarded. So essentially anecdotes of poaching. And so Wolf Patrol goes around just keeping an eye on hunters, particularly bear hunters, because bear hunters commonly hunt with hounds. And when they're in wolf territory, as you might imagine, there's a lot of potential for wolf-hound conflict. And so not only are the animals who are being hunted, the bears, at risk of very egregious treatment, you also have the hounds themselves who are placed in the service of these hunters. They're in harm's way if they come into contact with wolves. And what's even worse is that a lot of hound hunters, I should say bear hunters who use hounds, if their dog is attacked by a wolf, there have been stories of the hunters going out and retaliating and tracking down that wolf and then killing the wolf for harming the dog. So we have multi layers of potential harm to animals here. So that's what Wolf Patrol is out there to keep an eye on.
And are they keeping an eye on primarily illegal activities or both legal hunting practices that might be offensive to people that they might want to know about and that might not be illegal, and also anything that might be illegal? Do they cover the whole gamut? Or are they specifically looking for violations of the law?
They cover the whole gamut. They are most concerned about violations of the law, as you might imagine, and documenting evidence of illegal activity or potentially illegal activity is important not only for the public to know, but also for law enforcement to have evidence of if they are to enforce the law, these hunting laws, anti-poaching laws. But, to the extent that there are certain types of even legal hunting activities that many members of the public find potentially morally reprehensible, Wolf Patrol will be, the eyes and ears looking out for those types of things as well.
Now, you mentioned that your plaintiffs aren't actually Wolf Patrol, but that because Wolf Patrol exists, that's what has caused this statute to come into being. But before we get to the statute, let's talk about who your plaintiffs actually are.
So we have 3 plaintiffs. Our first named plaintiff is a film professor named Joseph Brown, who lives in Milwaukee, Wisconsin. He teaches film production at Marquette University, and he is also a working documentarian. So in his tenure track position at Marquette University, he actually, in addition to teaching, he is expected to publish creative work, and he has chosen to focus specifically on Wolf Patrol, the activities of Wolf Patrol, and hunting in Wisconsin in general. And so our second plaintiff is a man named Louis Weisberg, and he's a journalist. Specifically, he's a publisher and editor-in-chief of a newspaper called the Wisconsin Gazette. Mr. Weisberg has regularly disseminated information about wolves and bears and hunting in general in the state, and so he is impacted by this law because if people can't go out into the woods and document evidence and activities of hunters, then he can't report on it. So he has a direct interest in seeing this law struck down. And then finally, our third plaintiff is a woman named Stephanie Lose, and she is an environmental and animal rights advocate who often volunteers with Wolf Patrol. So she'll go out into the forest with the Wolf Patrol crew occasionally and help monitor hunting and trapping activities.
And just for those who have been in the animal rights movement for as long as I have and are as old as I am, I just want to mention one of the names I saw in your papers was Rod Coronado, who is an activist who goes way, way back. And he is one of the principals of Wolf Patrol. Isn't that right? Rod Coronado is one of the people active here?
Yeah. He is one of the more outspoken vocal actors in the Wolf Patrol movement. So yeah, a lot of the footage that Wolf Patrol posts on their YouTube channel and whatnot features Rod talking about, the day's activities, what things that they witnessed and that sort of thing. But Rod himself is not one of our plaintiffs.
Right.
We figured that we have a really nice, diverse group with these 3. We have our activist in Stephanie. We have our print journalist and a filmmaker / documentarian who's also a university professor. So as that shows, a lot of different interests are impacted by this law.
Absolutely. Before we get to the facts about what happened to these plaintiffs, let's just talk a little bit of background on the law.
Now, there have been restrictions on what is known as hunter harassment, quote unquote hunter harassment in Wisconsin for a long time, and prior to the statute that you specifically have a problem with. Can you tell us a little bit about what were those kinds of restrictions that existed before, and how this new statute, which I understand was enacted in 2016, expanded those restrictions?
Yeah. So prior to the amendment in 2016, Wisconsin's quote-unquote hunter harassment statute prohibited activity to an extent that is fairly common to hunter harassment statutes in all 50 states. Most states, if not all states, have some version of a statute that protects hunters from activists, essentially. You know, if you look back through the annals of history of the animal rights movement, you can look back to England, even when folks who called themselves hunt saboteurs went out and would disrupt traditional English hunts by, trying to scare away the fox, for instance. And that practice has carried over to the states. And in response to that type of direct interference activity, most states have passed some type of law that says, no, you can't actively impede a hunt. You can't go around making a bunch of noise to scare away the targeted species. You can't scatter various scents around that will make them avoid the area. And so those type of activities are what the Wisconsin statute initially sought to ban. And there have been some legal challenges to statutes like that, but for the most part, states can claim some type of legitimate interest in, preventing that degree of interference with hunting activity. But things changed in 2016. The state really kicked it up a notch.
And what were these new restrictions that were imposed?
We're faced with a statute that actually starts to look a lot like the ag gag laws, which your listeners are probably familiar with, and which the Animal Legal Defense Fund has successfully struck down in a number of jurisdictions. This law is very similar in that it actually prohibits photographing, videotaping, audio taping, or otherwise using electronic means to monitor, record hunting and trapping activities, or hunters and trappers themselves. And, bear in mind that these are restrictions on photographing and audiovisual recording in a public place, and not only a public place, but, a traditional public forum. And we can get into that in a little bit.
Yeah, actually, now that I'm asking you this question, maybe it's worth just reading out this statute. I know that's a little tedious, but I think everybody will understand the case a lot better if going forward. If we just it's subsection 2A7, is that right?
So we're actually challenging various subsections of the statute 29.083, and specifically the second subsection in that lists the prohibitions. And so, a lot of the new prohibitions are under subsection 2A7. But I'll just briefly read the portions of the statute that we are challenging.
Yeah, no, that would be helpful, yeah.
Sure. So we are challenging the prohibitions on, quote, impeding or obstructing a person who is engaged in lawful hunting, fishing, or trapping. And I'll explain the grounds. We're challenging these various provisions on slightly different constitutional grounds, so I can get into that more. The next prohibition we're challenging is, quote, impeding or obstructing a person engaged in an activity associated with lawful hunting, fishing, or trapping. So that's very similar to the first one. And then we get to the really juicy stuff where we're challenging prohibitions on, as I said, photographing, videotaping, audio taping, or through other electronic means, monitoring or recording the activities of a person engaged in hunting, fishing, or trapping. And here's where it gets really crazy. The statute even includes prohibitions on maintaining a visual or physical proximity to a person who is hunting, fishing, or trapping, and also approaching or confronting the person. And that's pretty much all verbatim.
Those particular violations would also, they require 2 acts and a specific intent. Is that right?
Yeah. So here's where the statute gets really hyper-technical, and where I suspect the state is going to try to fall back on in defense of the constitutionality. It says that these various things are only prohibited and only criminal if done in a series of 2 or more acts carried out over time, however short or long, that show a continuity of purpose and that are intended to impede or obstruct a person who is engaged in hunting, fishing, or trapping. So we've got a lot of kind of squishy language there that we think the state is probably going to point to try to justify the constitutionality of its law. But we're pretty confident that that is woefully insufficient.
So now we've got a basic idea, or hopefully people were able to follow that and have a basic idea of what the law is that is the problem. But now let's put it all together. How has this statute been used against your plaintiffs up to now? And maybe even more important, how have they changed their behavior because this statute exists?
The statute has affected each of our plaintiffs in slightly different ways. So as I mentioned, our plaintiff, Professor Brown, is actively working on a feature film about wolf hunting in Wisconsin and the activities of Wolf Patrol. And there have been many instances of hunters who catch sight of Professor Brown and the Wolf Patrol crew filming, in the distance, and they become irate and approach the crew demanding they hand over their footage. They often will evoke the law and say photographing, filming hunters is illegal in Wisconsin. Give me your footage. I'm calling the police. And many times the hunters do call the police. And Professor Brown and our plaintiff, Stephanie Lose, are detained sometimes upwards of several hours, questioned by law enforcement. And this charade waylays these plaintiffs for several hours, and this is time that Professor Brown could have spent filming. Our plaintiff Stephanie Lose has been told that she's been cited for violating this statute, but the next day when she went to go pick up her ticket, the clerk had no idea what they were talking about. So no one has ever actually been cited under this law, but the threat of prosecution is constantly looming over their heads. And as I mentioned before with our other plaintiff, Louis Weisberg, the journalist, he is directly impacted because if people can't go up there and observe what's happening with hunting and trapping in Wisconsin, then he can't report on it. And so that is also a direct chilling of his speech. He can't send a reporter up there for fear that he too will be prosecuted under the statute. So in a nutshell, all 3 of our plaintiffs have been chilled in their expressive activity, and the hunters themselves have been greatly emboldened by the enactment of these 2016 amendments on various other occasions. Big groups of hunters in their very large pickup trucks have surrounded Wolf Patrol members and literally barricaded them in while they, berate them and threaten them. Nevertheless, it's these Wolf Patrol members who end up getting harassed by cops and by, and being threatened with legal repercussions. And the hunters themselves just stand back and, smirk and think, oh, look at this, this law is great. So, in various ways, the statute has had a chilling effect on our plaintiffs.
Yeah, I think it's so telling that that people are threatened, and she was, as you pointed out, she was even told to show up to pick up her citation, and then there isn't. I mean, if there was a citation and then there was a prosecution, then you'd have then you'd be in court and you could challenge the statute in that way. But instead, obviously, where it seems obvious that they're trying to avoid getting into court. And that's why you're bringing them into court in this way, I assume, to actually get it before a court and get a decision as to whether this is unconstitutional. So who are you suing?
So we're suing the state of Wisconsin, but I just wanted to make one point in response to the comment you just made. So one benefit of bringing a pre-enforcement challenge like this one is that, as the suing party, we can choose to be in federal court because we are asserting violations of the U.S. Constitution. Whereas, if we were challenging the constitutionality of this law in response to a prosecution, and we'd be on the defensive side in that case, then we'd be in state court, which is probably, Wisconsin state court is surely going to be a less friendly place for the type of people like our plaintiffs. So that's just something as a tactical matter that, a lot of animal lawyers have to keep in mind, and any constitutional lawyers who try to strike down these type of laws.
Who are the defendants? Who are you suing?
So we're suing the state of Wisconsin, essentially, but the laws of the state that essentially dictate who can and can't be sued require us to name the individual district attorneys of the counties where Wolf Patrol is active. We also are suing the governor of the state in his official capacity and the state attorney general. So it's all just a procedural way of suing the state and saying, look, you can't enforce this law. So if you look at our caption, it's like a huge block of names. It's not particularly efficient, but, an injunction, which is what we're we're ultimately hoping to get in this case, would apply, not only to the named plaintiffs, but in theory to anyone within the state who has jurisdiction to implement this law. So that's the way we had to go about it.
So, now we're going to get to the lawsuit and the specific causes of action. But before that, what kind of penalties are there under this statute?
The penalties are criminal and civil in nature. So and I believe this was also an addition to the statute that was added in 2016 with that big overhaul that created all these problems. So in addition to criminal penalties, being charged with misdemeanor